All right, let's go ahead. We'll get started. We'll do first the House Bill 298. I am second signer on that, and I'll let Mr. Fleming preside. If you would, Mr. Fleming, and I'll present it.
All right, we'll have before the committee now House Bill 298. Mr. Chairman, if you want to go ahead and present that to us.
I will do so. Thank you. This is a bill filed for the primary purpose of taking out what is a sunset provision in Code Section 911-4.1 dealing with the private process servers. The bill was enacted, I believe, in 2009, as I recall. We had it for 5 years as a matter of reviewing, at this point in time, determine the effectiveness and ability of the program to function. You have in your file a document that was prepared by the Administrative Office of the Courts, which outlines what's being done. And currently we have 364 applicants have taken the examination and have been qualified through their education programs and testing to serve as process servers. This is, I think, a substantial improvement, because prior to the original enactment of this law, there was not in place anything that gave, for the benefit of the courts and the practicing bar, some guidance as to those individuals who may qualify to do service of process in Georgia. And as those of us on the committee, as attorneys know, it can be a very complicated and sometimes difficult law to follow, to be sure that you're getting process service done correctly. Of course, the sheriffs still have and have always had and will continue to have the right and obligation to serve process through the courts. This is to give just another option for the clients of attorneys who wish to do so, to employ in those areas where they've been accepted for service the use of a private process server. We recognize that the ability to have these people is certainly beneficial for the courts to have qualified people doing it, and I know that I use them from time to time myself in the metro areas. It's important for many reasons. You may want to have service made at as quickly as possible. You may have problems sometimes locating a person, and you can give a private process server specific information and have direct communication. You can't always have that ability through the sheriff's office in performing service process. So with that background, the work has been underway for 5 years. It's been, I think, very successful. We have some people with the Administrative Office of Courts who may wish to speak on how this program is set up, and I'd like them to talk about it if they would. So if you want to come forward, I can have a seat. I'd like to have you give some further background information on it.
Mike, most of us know you, but go ahead and tell us who you are and who you're with.
This one?
Yes,
sir. My name is Mike Kikero. I'm with the Judicial Council Administrative Office of the Courts. We, under 911-4.1 and the rules of the Judicial Council, implemented the Certified Process Servers program in conjunction with Georgia Sheriff's Association. And we've been running those tests now for about 3 years. There is a 12-hour certification training that is run by a training group, which is the Georgia Association. Paul, you might help me. Georgia Association of Professional Process Servers, who run the training. The AOC itself runs the testing, which is testing has been vetted by a national professional group to ensure that it's fair, and we continually vet those questions to make sure that they are updated with current law from year to year. If there's any specific questions, one other thing I can say is that our training and testing is also used by counties and judges who employ authorize permanent process servers. Those are particularly metro counties that do that.
Okay. Thank you, Mr. Carroll. Representative Caldwell, you had a question?
I don't have a question. I just want to make a motion, Ladon.
All right. Let's. Are there before we take a motion? Are any other questions of the chairman or Mr. Carroll? Hearing no questions, is there a motion?
I move do pass.
There's a motion to pass. There's a second. Any discussion on the motion? All those in favor, please indicate by saying aye.
Aye.
Any opposed? Motion passes.
Thank you, Mr. Chairman.
Mm-hmm.
Back over, we're still short. Mr. Mitchell, if he wants to come in and get his bill presented, or we'll pass over it. I'm waiting for him.
Oh, is that time?
Thought you want to get your bill, ma'am.
Mr. Chairman, absolutely. This is great legislation authored by a brilliant legislator. I must say, Mr. Chairman, HB 115 is the identical bill that was brought before this committee, flew out of here without one nay, without a dissent, perhaps because the chair was a co-sponsor of it last year. But it is the exact identical bill. It simply allows a consumer who gets him or herself in a difficult situation, gives them the absolute right to cure that defect by paying all past due fees, late charges, and of course the legal fees that have accrued up until that time. As most of you on the committee knows, that once a debtor falls behind, and when you close on your mortgage, I want to make sure that the judge hears this. When you close on your mortgage, within those documents is an agreement which states that if you fall behind, the bank can essentially take your home without going through a judicial forum. Essentially, after that, your contractual late period is up. It is up to the lender. I want you to hear me. This is up to the lender whether or not your late payments are accepted at that time. Well, this gives the consumer the absolute right to cure that. That's significant if you have a lot of equity in your home. Very significant. But this is a bill that virtually everyone on the who has an interest in this has agreed to it. And it is prospective legislation, meaning that it will not interfere with any present contractual obligations. We'll be just going forward as of the day it becomes effective.
Any questions of the presenter? Yes, sir. Go.
Representative, we had this conversation during the subcommittee. Do not the federal regulations that's in place today require a 120-day foreclosure period that the bank or mortgage or whoever's holding it can't do anything once they notify them for 120 days?
I checked up on that, and that essentially is an advisory statement from CFPB, does not interfere with the present contractual obligations, is what I've been told, that presently exists. So does it require? No, it does not.
And correct me if I'm wrong, but the gentleman was here testified, an attorney who represents these people, the mortgages, and he agreed with me at that time that I was correct and this was redundant legislation. And if I'm wrong, I'm just asking you.
He had a different perspective when I talked to him later on.
Oh, okay. Well, he hadn't told me that. Okay.
It was called the Mo Thrash Act. He worked for Mo Thrash, and I think you'll have a different perspective if you talk to him today.
Okay.
Further questions of the presenter? Let me ask you. Yes, sir. That was yours, Mr. Fleming.
Thank you, Mr. Chairman. Representative Mitchell, so tell me again what the problem is and what we're fixing.
At present, in this state, you get behind on your mortgage.
Right.
Once you get past your contractual late period.
Okay.
If you have a traditional mortgage, you may have a 10 to 50 day.
Something like that.
Exactly.
Right.
It is from that point on, it is up to the lender.
Right.
To determine if they accept your late payment or not.
Okay.
What this bill will do, if you come up with the money, you refinance, you hit the lottery, you borrow from friends, they will in fact have to accept your late payments. and get you back on, as opposed to you perhaps trying to reach the lender to no avail.
No matter what the contract says you signed.
No, this is a prospective legislation. It will not interfere with present contractor relationships. Just going forward,
So
this will be a provision in the contract.
So maybe this would be a question: are we barring someone from putting this in a contract, or are we saying any contracts in the future that don't comport with this are overridden? I guess I would say.
No, it would say that any contract in the future will contain this provision, allowing the consumer to do what the bank said that they wish to have happen anyway.
Okay, so and I don't do home loans and I don't do closings, and so I'm trying to educate myself on this.
Fair
So,
All right.
what is to prevent a consumer right now from shopping their mortgage to a lender that would allow a longer, I guess, cure period, a time to cure their late payment versus what's in the contract that they're signing that you don't like?
Well, the traditional contract just does not allow for that. It allows for you to have your contractual late period, as you mentioned,
Right.
about 10, 15, 20 days, and then that's
Right.
it.
Right. And I mean, I assume there's a reason for that. I mean, if you're going to enter into a contract to buy the house and make the payments, then you need to make the payments, and if you're late, then there are
I think
penalties.
everyone agrees with that, and this does not get the borrower out of paying one single cent that is owed to the lender. In fact, it also says that you be contractually obligated to pay your late fees and any attorney's fees that have accrued and the like.
All right, last question. I once again don't do this, don't really understand this, so I'm trying to figure it out. Obviously, the lenders are going to be affected by this. Have they expressed any?
They support the legislation.
They support the legislation.
Absolutely.
Okay, thank you. Thank you, Mr. Chairman.
Yes, sir. Other questions of the presenter? I think, Ms. Mitchell, to be emphasized, what you were saying is under Section 2, where it says this act shall only apply to security instruments executed on or after July 1, 2015, which is the effective date of the act.
Thank
So
you, Mr.
what
Chairman.
we're doing is putting a contractual obligation for those security instruments in the future.
Absolutely, Mr.
All right.
Chairman.
Any other questions? Thank you, sir. Anyone else wish to speak to the committee on House Bill 115? Anyone else? If not, we will close all further public comment. And the bill is now in the breast of the committee and discussion among committee members. There being no further discussion, the chair will entertain a motion.
Motion do pass. Second.
Have a motion do pass with second. Any further discussion on the motion? Chair will call for vote. All in favor signify by saying aye.
Aye.
Opposed, like sign.
No.
Chair,
The ayes got it.
please, you better let me be the one to say that, whether you don't mind, Mr. Mabry. I'm still chairing the committee, I believe. It's the opinion of the chair. The motion carries. All right, thank you.
Mr. Chairman, thank you so very much, ladies and gentlemen of the committee.
Next, we have House Bill 197 by Mr. Jacobs. Mr. Jacobs, if you would indicate where you're seated, all right?
All right. Thank you, Mr. Chairman. What's the number? Thanks. House Bill 197 is a trifecta of uniform laws in the debtor-creditor area. These are all updates to existing uniform laws that are on the books that Georgia does not have the most current version of. The three that the bill mainly deals with are Article 1 of the Uniform Commercial Code, the Uniform Fraudulent Transfer Act, which we will be renaming the Uniform Voidable Transactions Act, and the Foreign Country Money Judgments Recognition Act. I guess I'll take the biggest of the three first, and that's the Uniform Commercial Code. Article 1 of the UCC, of course, is all of the substantive rules that apply to the rest of Article 1 of the Uniform Commercial Code. All the other articles, the rules of engagement, are contained in Article 1. Georgia is one of only 3 states that have not. This update to Article 1 was adopted back in 2001, and Georgia by the Uniform Law Commission, and Georgia is one of only 3 states that have not adopted or that has not adopted revised Article 1 of the UCC. So this will leave it so that there are only 2 states who have not adopted this particular article of the UCC. It makes a significant number of definitional changes. Also changes up the definition of good faith to mean honesty in fact and the observance of reasonable commercial standards of fair dealing. Good faith, of course, is a concept that kind of permeates throughout the Uniform Commercial Code. It also adds course of performance as a criterion for interpreting a contract and puts course of performance between the 2 particular contracting parties on the same level as course of dealing and usage of trade, which are 2 concepts that already exist within Article 1 of the UCC. There are a whole lot of changes in there, but those are kind of the main substantive changes. It will finally bring Georgia's Uniform Commercial Code into compliance with how it reads in all of the rest of the country, except for 2 other states.
Let me ask you, if you would, I might suggest we bifurcate this into the 3 sections you have. You want to do that? So, talking about the UCC provisions, does anyone have any questions of Mr. Jacobs regarding that area? There are none. Go ahead.
And I should also say that we did make an accommodation to the bankers on the effective date of Article 1 of the UCC. They have a lot of forms, obviously, that are based upon the provisions of the UCC, and so they had wanted the effective date to be pushed out, and so we've made it July 1st, 2016 for that particular section of the bill.
All right.
The second is the Foreign Country Money Judgments Recognition Act. This is and it already exists on the books in Georgia. We're just updating it. This is the portion of Title IX that deals with domesticating an out-of-the-country judgment here in Georgia. And, of course, then we also have a separate uniform law that deals with recognizing the judgments of sister states. One of the things the update to the Foreign Country Money Judgments Recognition Act does is makes it clear that it does not apply to any judgment that the full faith and credit clause of the Constitution applies to, and of course the full faith and credit clause deals with the judgments of sister states. It allocates the burden of proof depending on what the subject matter is between the party seeking enforcement and the party that would be defending, and that breaks down in the Uniform Act exactly the way that you would think that it should. Somebody who has brought a claim for enforcement has to prove certain things about the judgment itself, and then other things that are in the nature of an affirmative defense would be the burden of proof would be borne by the defending party. It is more specific in terms of the procedure for seeking enforcement of a foreign judgment, an out of the country judgment. That is, sometimes the uniform law that deals with enforcement of sister state judgments gets conflated in that regard with the uniform law that deals with foreign country judgments. With a sister state judgment, you simply have to file it within the with the clerk of court, and then serve that by mail on the opposing party, because you're basically looking for recognition of something that enjoys full faith and credit. We make it clear in the Foreign Country Money Judgments Act, that you actually have to initiate a civil proceeding, serve it, with a claim, with an actual formal claim made in a complaint, and serve that in accordance with the Civil Practice Act, and then the Civil Practice Act would apply to a proceeding under this particular uniform law. And also, for the first time, it has a statute of limitations that runs from for 15 years from the rendition of the judgment in the foreign country.
Well, may I ask a question on the filing of the action here? It would be filed as a new action with the court, and the action, does it go to the merits of the claim and the right of obtaining judgment at all, or is it just a matter of perfecting the ability to have that judgment enforced in this state?
No, I mean, you would have to make there is at least some minimal showing of due process that you would have to. I mean, there is a higher showing that needs to be made than simply, here is my judgment and the law enables me to recognize it, or to have it recognized, and that's part of the new the respective burdens of proof that are now contained in the updates to this particular Uniform Act. It's not as simple as just filing a complaint seeking enforcement of the foreign judgment.
Thank you. Let me a step further. You mentioned the statute of limitations being 15 years, which is different from what we have as a statute of limitation on judgments, whether it be domesticated judgments or even what we call under the Uniform Foreign Judgment Act, which addresses the judgments of our sister states. I believe those are 5 years. We did a little checking beforehand. Is it justified for us to give a longer time of a statute of limitations, which I assume can also be renewed as we do with other judgments? In this case, 15 years to a foreign judgment, which would be greater than that which is given to either what we call a sister state judgment or even a judgment within our own state.
I think that in this instance that it does make some sense, because you're dealing ultimately with international commerce and a Uniform Act that is being adopted on a fairly broad basis throughout the country. Ultimately, when someone has a foreign out of the country judgment and is seeking for it to be enforced in Georgia for someone that is domiciled here, I think from an international commerce perspective, they should know that the uniform law treats them the same as they would be treated if they were doing this very same thing in another state, because ultimately, who you're seeking to have it enforced, the person that you're seeking to have it enforced against is just by happenstance here in Georgia. I mean, I think in this regard the uniform law should be the same, because you're dealing with international commerce all across the country.
Have the other states in their enactments, how many states have in fact enacted?
I would need to go and check, but I believe it's more than half.
More than half. And in those places, have all of them recognized the time frame of 15 years for the statute of limitations?
And that I would need to go and check on as well, Mr. Chairman, and I certainly will do that before we get to the House floor with this one. But this particular Uniform Act is one that we've been significantly behind in updating. The initial act was created back in 1962. This update to that Uniform Act was adopted in 2005, and we're about 10 years behind on it.
Do I understand that we do have recognition in Georgia now of a foreign country's judgments under our statutes, but this will be an updating of it?
Correct. This is an update of the existing statutory scheme, which is also a uniform law.
And under the current law that we have, do we have a statute of limitations applicable, or is it to be what is the normal provisions of Georgia law on limitation, or do you know?
I think the answer is that it would default to whatever the current law is, because the statute of limitations is a new add with the 2005 Uniform Act.
All right. I would like for you to do that. If you would, let's do a research over what has been happening as far as viewing the other states in this area. I think it'd be helpful to certainly be uniform with what's being done, but it is such an extensive time based on what you have as far as judgments in Georgia, that we at least look at some compatibility with that language and provision. Thank you.
That's fair, Mr. Chairman.
Madam, you want to speak? Put your mic up so if you don't mind.
If you're going to do 15 in this new act, and the law says 5, do we need to be amending where we have 5 and say except as provided in this new? It's 15 because the way
does that address just what we call the Uniform Foreign Judgment Act, or is that?
It says all actions upon judgments obtained outside the state, except judgments for child support, spousal support, 5 years. So I'm wondering if we need to make a cross-reference here.
We probably will.
9-3-.
I'm going to suggest, because of that, the questions we have, if the presenter would be amenable to having the bill held over till we have a next meeting to do that.
That would.
There's apparently a conflict with what we currently have.
That would be fine, Mr. Chairman, or we could recommit it to subcommittee. I happen to have a meeting at 4 o'clock today.
I understand. Well, I would consider that in a minute. You have a question? You waving? All right. Anything further from committee members or the presenter? You had a third section.
Well, the third section is the Uniform Voidable Transactions Act, which is the old Uniform Fraudulent Transfer Act. I think the biggest change, frankly, is just the change of the name. I think we've encountered this act 1 or 2 times before where I've said, even though it says fraud, we're not talking about a actual fraud here. The name suggests fraud, but the reality is it's just a transaction that was made for little or no value that keeps the asset out of the hands of your creditors. That's not fraud per se. It's what we're now going to call it is a voidable transaction. There is a choice of law provision that says in the new Uniform Act that says that the law that would apply is the law of the jurisdiction where the debtor engaged in the transaction. So ultimately, Georgia's Uniform Voidable Transactions Act would apply where for any transactions that occur in Georgia, and then it's similar to the burdens of proof that are set out in the Foreign Country Money Judgments Recognition Act, where this version of the Uniform Voidable Transactions Act is clearer as to who has the burden to prove what, and again, it goes to who is making the party that is making the claim of there being a voidable transaction has the burden to prove that, but then there are certain affirmative defenses available in the act that would fall upon the defending party. So that's the Uniform Voidable Transactions Act. I think it's actually, I sat through the consideration of this one in the Uniform Law Commission in 2014, and I will say that it's a significant improvement upon the existing Uniform Fraudulent Transfers Act, and already has been introduced in 15 states, even though this is the first year that it's been put out there.
Thank you. Any questions of the presenter? There are no questions. The chair will exercise its prerogative and have this recommitted to the subcommittee to review the statute of limitations questions as raised by legislative council and the other states. Thank you. Yes, sir.
If I may, Mr. Chairman, I will add this bill to today's agenda at 4 p.m.
All right. Anything further to come before the committee today? If not, we'll stand adjourned. Thank you.